This video is made for educational purposes only and cannot be taken as legal advice. Mr. Justice Warby, this is an assessment of damages for breach of confidence, misuse of private information and breach of contract, and compensation under the Data Protection Act 1998. It follows an order made on the 27th of November 2019, by which the defense was struck out and judgment was entered for the claimant on liability. The factual and procedural background. The claimant and the defendant are both celebrities. He is a martial artist, known as a cage fighter, who appeared on and won the TV series Big Brother. She is a well-known TV personality and author. She is a former glamour model, who is also known by the stage name Jordan. In or about 2009, the claimant and defendant became a couple. On the 2nd of February 2010, they were married. The relationship foundered within about a year, and a divorce was finalized on the 20th of March 2012. During the relationship, in October 2009 and June 2010, the defendant obtained video recordings and photographs of the claimant engaged in sexual activity, the private information. As a result of disclosures later made by the defendant, the claimant sought, and on the 12th of September 2011 the defendant gave written undertakings to the claimant that she would not, except in certain specified and limited circumstances, publish or disclose or cause republication of the video footage or any stills, or any description of the claimant's sexual acts recorded on the footage. In 2017, the claimant sued the defendant for all the wrongs I have listed above, as well as harassment, contrary to the Protection from Harassment Act 1997. His pleaded case was, and is, that on a number of occasions in and between about 2012 and the 9th of January 2018, the defendant disclosed all or part of the private information to third parties, numbering at least 50. He also complained that she had breached the undertakings by publicly describing one aspect of the private information. The claimant's claim was for an injunction to restrain further breaches of his rights, damages, and other orders. The claim form stated value. For issue purposes, the claimant's damages claim is limited to £25,000. That limitation reduced the fee payable upon issue. On the 19th of December 2017, an application was filed for an interim injunction pending trial, to prohibit disclosure of the personal information and any other processing of the personal data it contained. The claimant did not proceed with the application at that time. But on the 16th of April 2018, the harassment claim was dropped by way of an amendment and, at the same time, the claimant revived his dormant application for an interim injunction. On the 25th of April 2018, sitting in the interim applications court, I heard an urgent application for such relief. I concluded that the time estimate of 1 hour was inadequate, and the matter was not urgent. I adjourned the application for hearing in May 2018. On the 18th of May 2018, the application came before J.J. The judge heard counsel for the claimant and the defendant, and read witness statements from each of them. Having considered the test provided for by S-12(3) of the Human Rights Act 1998, the judge was satisfied that the claimant's prospects of success at a trial were sufficiently favorable to warrant the grant of interim relief. He made an order, which largely followed the Model Interim Non-Disclosure Order attached to the Master of the Rolls Practice Guidance of 2011. The order contained provisions requiring the defendant to deliver up to the claimant's solicitors within 48 hours all copies of the private information within her possession, and to provide disclosure of information, including details of what pieces of private information she had, and what she had done with them. On the 24th of May 2018, the defendant made a second witness statement, in purported compliance with those provisions. On the 14th of June 2018, a defense was served, admitting that the defendant had obtained the private information, but denying liability. The defense maintained, among other things, that the recordings were made with the claimant's knowledge and consent, that the undertakings were non-contractual, that the defendant had not made any such disclosures as alleged, and that she had not retained any of the information since January 2014. On the 17th of March 2019, the defendant gave notice that her solicitors had ceased to act for her, and that she was now acting in person. On the 3rd of April 2019, the claimant's solicitors sent a hearing bundle for the case management conference to the defendant's home address by recorded delivery. On the 17th of April 2019, the case management conference took place. Directions towards trial were given by Master Gideon. A trial date of the 9th of March 2020 was provided for, and directions for disclosure and exchange of witness statements were given. The order contained a prominent warning to the parties that they must comply with the terms imposed by the order, otherwise your case is liable to be struck out. At a hearing on the 27th of November 2019, Master Davison determined that the defendant had failed to comply with Master Gideon's directions. He struck out the defense, and directed that judgment be entered for the claimant for an injunction, to last until the 27th of November 2024 or further order, delivery up of any documents or devices on which the private information had been stored, and for damages and compensation, to be assessed at this hearing. The claimant is present and represented. But the defendant is not present or represented, so the first question for consideration is whether I should proceed in her absence. I have concluded it is right to do so. Where a party fails to appear at the hearing of an application, the court may proceed in their absence. This is a power that must be exercised in accordance with the overriding objective. The court should be very careful before concluding that it is appropriate to proceed in the absence of a litigant in person. That is not the situation here, however. The defendant has not sought an adjournment. Where a litigant fails to appear without giving a reason, it is necessary to consider first whether they have had proper notice of the hearing date and the matters, including the evidence, to be considered at the hearing. If satisfied that such notice has been given, the court must examine the available evidence as to the reasons why the litigant has not appeared, to see if this provides a ground for adjourning the hearing. Restriction on proceedings and remedies. 1. At any time when an individual has been made bankrupt, the court may stay any action, execution, or other legal process against the property or person of the debtor or, as the case may be, of the bankrupt. 2. Any court in which proceedings are pending against any individual may, on proof that he is an undischarged bankrupt, either stay the proceedings or allow them to continue on such terms as it thinks fit. These provisions envisage that once a person becomes bankrupt, a claim already commenced against them will continue, and execution may be levied against the bankrupt's property or person, unless the court decides to impose a stay. It is clear that the defendant's trustee in bankruptcy is aware of these proceedings. Mr. Gur's evidence is that the trustee has told him that the defendant is not engaging with that process, and has failed to attend 3 appointments with the official receiver to establish her assets and liabilities. There has been no application by the defendant, the trustee, or the official receiver for any stay of this action. On the evidence and information before me, I am satisfied that it is right to proceed, and to hear the trial, on the express condition that the judgment will not, without further order, be enforceable against the defendant otherwise than by proof in the bankruptcy, and that any process of execution is accordingly stayed, until further order. That brings me to the question of how I should approach the assessment process. First, I need to identify the wrongs for which my order is meant to compensate the claimant. As I understand the position, Master Davison's order to strike out was made pursuant to CPR 3.4(2) c, on account of the defendant's disobedience of the directions given by Master Gideon in what was an unless order, and the judgment on liability, together with the injunction and order for delivery up, were consequential orders pursuant to Regulations 3.4(3), which provides that where the court strikes out a statement of case, it may make any consequential order it considers appropriate. The wrongs for which the claimant is to be compensated. The amended particulars of claim identify 2 components to the private information: video recordings and/or photographs obtained by the defendant. 1. On or about the evening of the 12th of October 2009, when the claimant and defendant were staying at the Mayfair Hotel in London, and 2. On a date in or about June 2010, when the couple were staying at the house of 2 of the defendant's close friends. The information has 2 main aspects to it. The first is that the claimant is shown dressed as his cross-dressing alter ego Roxanne. The other is that the recordings depict sexual activity of the defendant and/or claimant. In saying this much, I have set out some of the information recorded in the confidential schedule to the amended particulars of claim, but this public judgment needs to provide enough to allow an interested reader to understand my decision. In all the circumstances, I do not consider it unduly intrusive to identify the occasions on which the private information was acquired and captured on video, or the general nature of that information. Counsel's skeleton argument for this public hearing refers to the claimant having enjoyed cross-dressing and having experimented with his sexuality. The claimant himself has said in his evidence to the court, "I accept it is now widely known that I engaged in cross-dressing and had an alter ego called Roxanne," and he has admitted giving a number of interviews on the topic. Whilst accepting that his cross-dressing has entered the public domain, the claimant blames the defendant for this, on the grounds that she outed him by showing photos at Simon Cowell's 50th birthday party in November 2009, but that disclosure, over 10 years ago now, is not one of the wrongs complained of in this action. More detail about the private information is given in the confidential schedule, but it would not be appropriate to place that on the public record in this judgment. Although the very nature of the claim is that some of the private information has been disclosed, in ways to which I shall come, and to some extent it may by now have lost the quality of confidence, it certainly cannot be said that the disclosures made have wholly defeated the claimant's privacy or data protection rights. The acts that are alleged to constitute the wrongdoing are these: the defendant's unlawful acts, disclosure of the private information in breach of contract, breach of confidence and amounting to a misuse of the claimant's private information. The evidence of the claimant. The claimant has made 6 witness statements, the last of them a short statement for this trial, which incorporates by reference 5 earlier statements made for the purposes of interim applications. At this hearing, he confirmed those statements on oath and answered a small number of questions from me. The defendant being absent and unrepresented, there was no challenge to any of his evidence. Assessment. Mr. Williams submits that on the facts of this case, and in the light of the established principles, an award of more than £60,000 would be justified. He refers me to the awards made in Galati to Alan Yentab, of £85,000, and Lauren Alcorn, of £72,500, and submits that it is arguable that the claimant's claim merits more than either. He submits that the wrongdoing has destroyed the claimant's life, and points, in particular, to the systematic, widespread and long-standing nature of the wrongdoing, and the many aggravating features of the case that I have already identified. Having said all that, Mr. Williams accepts, in the light of the rubric on the claim form, that without an amendment he cannot seek an award in excess of £25,000. He has not sought permission to make any such amendment, noting that the fee for doing so would be at least £5,000, which the claimant would likely never see again. In those circumstances, it suffices to say the following: I am satisfied that this claim merits an award of at least £25,000, and that is the sum that I award. I bear in mind that an aspect of the harm which is in evidence derives from taunts about the claimant's cross-dressing, but that was no secret by the time of the wrongs with which I am concerned, and the claim does not arise from disclosures of that nature. For those and other reasons, the case is not directly comparable with Mosley, in which the claimant's previously secret sexual preference was revealed in detail to millions by a popular Sunday newspaper, in a front-page splash published without prior notice. Nor are the facts comparable with those of the phone hacking cases considered in Galati, the essence of which was unauthorized access to personal information. I do not accept the entirety of the claim put forward on the facts. I cannot find, on the balance of probabilities, that the threats and insults referred to were, or were all, attributable to the acts complained of. Some, such as taunts of paedophile tendencies, involve allegations which it is impossible or at least hard to link with the wrongful disclosures, as opposed to the matters relied on in aggravation. There is enough in the documentary evidence to identify other potential causes, and I do not have enough evidence to make a finding in favor of this aspect of the claimant's case, cf. Baron v. Vines, 2016. Nor can I conclude that the psychological problems of which the claimant has given evidence are attributable to the wrongs in respect of which the defendant has been found liable. To compensate for psychiatric harm, I would need much more detail of the symptoms, and a sound evidential basis, almost certainly including expert evidence, for attributing causation. The submission that the claimant's life has been destroyed is, in my judgment, a rhetorical exaggeration. Comparison with the tariffs for general damages in personal injury cases, Judicial College Guidelines, 15th edition, reveals that an award in excess of £60,000 would equate to the damages recoverable by someone who loses all sight in one eye, with damage to the sight in the other, or by a man made impotent in middle age. An award on that scale would seem on the extravagant side, on these facts, and out of kilter with recent awards for libel. I do, however, accept that the defendant's conduct has involved the deliberate exposure to a substantial number of individuals of moving and still images of the claimant's intimate sexual activity, which were taken without his consent and disclosed in the knowledge that he positively objected. Some of the disclosures were made to people who knew the claimant personally, and were known by him, including his ex-partner. He found out about these disclosures through mutual friends. Other disclosures were made on public occasions, to people who were complete strangers to the claimant and the defendant. In addition, the defendant has used graphic terms to describe an intimate sexual act to a media publisher, with a view to publication, and has thereby caused the publication of that description in an online article available to anyone and doubtless read by a very large number of people. I accept that the claimant has found it demeaning to have details of his sex life disclosed, repeatedly, in this way, and that he has suffered a real loss of personal dignity and harm to his self-esteem. The defendant's conduct has considerably aggravated the harm caused by the disclosures themselves. Her behavior has been persistent, flagrant, arrogant, high-handed, and inexcusable, and for those reasons very distressing and hurtful to the claimant. The claimant's perception that the defendant has lied about whether she retained copies of the personal information, and that she has acted maliciously, is reasonable, and he is entitled to be compensated for the distress he has suffered as a result. The defendant's frequent additional references or allusions to the private information, sometimes in threatening terms, have caused additional upset, rubbing salt in the wound. Damages of £25,000 would be comparable to an award for moderately severe psychiatric harm, or a neck injury leaving markedly impaired function. Applying the principles I have identified above, an award at that level or more is fully merited, on any view of the authorities. Costs. On the 27th of November 2019, Master Davison ordered the defendant to make an interim payment of £150,000 on account of costs. The Master had been told the defendant was bankrupt, but evidently saw no need or reason to stay execution of that order. As I have indicated, that may well be correct by virtue of S285, 3a, of the 1986 Act. But in line with the approach I have identified above, I shall impose a stay on enforcement of my damages award, the exiting costs order, and any further order for costs which may now be sought and granted in the light of my decision, but that stay shall be without prejudice to the claimant's right to prove in the bankruptcy.